Good evening, everyone. Welcome to day 9 of our bar review. We are exactly 180 days away from the bar examination. Today, we are tackling a very important topic: procedural laws applicable to actions pending the time of promulgation. Remedial law strictly governs the times and seasons of litigation. When the Supreme Court or Congress changes the rules of the game right in the middle of a lawsuit, it dictates a new season for that pending action. Do the old rules still apply, or do the new rules take over? We will find out exactly how this works today. But before we dive into the complexities of law, let us briefly reflect on our guiding verse from Ecclesiastes chapter 3, verse 1, which perfectly aligns with our topic. There is a time for everything, and a season for every activity under the heavens. That's Ecclesiastes chapter 3, verse 1. Not only does this apply to the shifting seasons of procedural rules, but for you, it is a powerful reminder that this grueling season of reviewing is only temporary. Right now is your season for hard work, sacrifice, and preparation, which will eventually give way to the season of harvesting your license. Let us begin. As usual, our discussion today will be structured into four levels as stated in our beer syllabus to help us properly digest the topic. We will look at the big picture, the essential pillar, the elemental principle, and the root level. Let's jump right into the big picture. Starting with the big picture, just like in day 8, our discussion still falls under the overarching umbrella of general principles. As a quick reminder, these principles are crucial because they establish the foundational framework and essential mechanisms required for the proper administration of justice. Everything we discuss today acts within this framework. Moving down to our essential pillar, we focus on the specific nature of procedural laws when applied to pending actions. To understand this, we must contrast it with substantive law. While substantive law operates prospectively, remedial or procedural law generally operates retroactively. This means new procedural rules are applicable to actions that are already pending and undetermined at the time of their passage. Why is this allowed? The Supreme Court has repeatedly held that there are no vested rights in rules of procedure. A litigant cannot insist on the application of the existing rules if they have already been validly amended, as these rules merely operate in furtherance of a remedy. Now we reach to the elemental principle. In law, general rules almost always have exceptions. Is the rule that procedural laws apply retroactively to pending actions absolute? The answer is a resounding no. The application of procedural rules to pending cases admits certain exceptions. Let us look at the first two. First, retroactive application is denied where the statutes or rule itself expressly or by necessary implication provides that pending actions are exempted from its operation. If the Supreme Court promulgates a rule and explicitly says they shall only apply to cases filed after January 1, then that intent must be respected. Second, a procedural rule cannot be applied retroactively if doing so would impair vested rights. Remember our test from day 8? If a new rule takes away a vested right, it ceases to be merely procedural. It crosses over into being a substantive matter, and substantive laws cannot be applied retroactively to the detriment of the party. Continuing with our elemental principle, here are the remaining highly critical exceptions. The third one is, under appropriate circumstances, courts must deny the retroactive application of procedural laws if doing so would not be feasible or would work an injustice. Procedural rules are tools to facilitate justice, not frustrate it. Court procedural laws cannot be applied retroactively to pending actions if doing so would involve intricate problems of due process or impair the independence of the court. Fifth, and this is the favorite in bar examinations, the exceptions in criminal cases. Any new rules may validly apply to pending criminal cases, except if the new rule permits or requires a lesser quantum of evidence to convict than what was required at the time of the commission of the offense. Why? Because applying such a rule retroactively would make it easier for the state to convict the accused for a past act, rendering it an unconstitutional ex post facto law. Always watch out for that in criminal procedure questions. Let us bring this down to the root level and see how the Supreme Court actually applies the injustice exception. A landmark case for this is Colmenar versus Colmenar, decided in the year 2021. In this case, the defendants filed their answers with affirmative defenses in 2018. While the case was pending, the 2019 amendments to the Rules of Civil Procedure took effect on May 1, 2020. Under the new rules, courts are mandated to motu proprio or on their own initiative resolve affirmative defenses within 30 days from the filing of answer. Relying on the general rule of retroactivity, the trial judge retroactively applied the 2019 amendments and motu proprio dismissed the plaintiff's complaint. Was the judge correct? The Supreme Court said no. While the 2019 amendments generally governed all pending cases upon effectivity, they should not be applied when application would not be feasible or would work injustice. In this case, the strict retroactive application caused a severe injustice because the plaintiff lost his substantial right to be heard on the affirmative defenses and lost his right to file a motion for reconsideration, rights he originally had under the old rules. The court emphasized that rules of procedure should never be applied to override substantial justice. Thus, the older procedure under which the case was filed had to govern. To wrap up our discussion today, here is a highly possible bar question that flawlessly tests the intersection of procedural retroactivity and constitutional limits. Let us read it carefully. In 2018, Congress enacted a new procedural statute designed to expedite the prosecution of complex financial crimes. Among its provisions, the law explicitly altered the rules of evidence, stipulating that for the crime of corporate fraud, the prosecution now only needs to establish guilt through clear and convincing evidence, instead of proof beyond reasonable doubt. John, a corporate director, is currently on trial for corporate fraud offense allegedly committed back in 2016. The trial is still pending, citing the established legal principle that procedural and evidentiary laws govern actions pending at the time of their promulgation. The public prosecutor files a manifestation praying that the court evaluate the evidence against Don using the new clear and convincing evidence standard. Is the public prosecutor correct in arguing for the retroactive application of this procedural law to Don's pending case? Now, I am not going to give you the answer just yet. I want you to sit with this problem. Apply the principles and the specific exceptions we just discussed today, especially regarding how procedural rules interact with the rights of the accused in criminal cases. Write down your best, well reasoned, beer style answer. Keep it with you because we will tackle this exact problem together and grade your answers after 3 days. Thank you for joining me on day 9 of our bar review journey. Keep the faith, keep grinding, and I will see you in our day 10 of review. Good evening, guys.